Further hearing in the appeal of Peninsula Securities Ltd against Dunstall Bangor Ltd.
Mr. Dunlop, good morning.
Good morning, my lord, my lady. My lord, if I could just start at the outset, this morning, yesterday, we were very helpfully provided with the latest edition of Hayden's text, the 1999 edition. And in reviewing
That's
that,
the latest, is it?
Well, we understand to be it may be
2018 is mine.
Oh, well, I haven't seen that, my lord.
Well, you ought to.
Yes.
That was the copy that I circulated, the extract.
Sorry, I hadn't realised that was the 2018, my lady.
Splendid.
In any event, that is the extract then which I hold, which is 2018. And within that, we have identified a couple of authorities in particular which we have provided to the court, two Canadian cases.
Thank you.
The first of those, if I could briefly open those to the court.
Let's just mark on our copy of Hayden where these cases are referred to.
Certainly. So, my lord, will see, my lady, the page 271, the ESO test is set out, and then a case is then recited, BACM Limited and Cowell, with the footnote 239. That is the first case to which we are going to refer. And then at that footnote 239, there is a reference to a second case of McDonald's Restaurants of Canada versus West Edmonton Mall.
Yes, thank you.
So the first of those, my lords and lady, is the BACM case, the decision of the High Court of Manitoba.
You've given a copy to Mr. Humphreys?
Oh yes, my lord, yes.
Perfect.
And the facts of that, there's limited analysis in any event, my lord, but just in terms of the facts, I could briefly take you to those. The applicant in the case was BACM. It was intending to sell certain lands to the respondent called Cowell. There were restrictions in a lease between BACM as lessor and a lessee called Crej. And the issue related then to the impact of those restrictions on what Cowell, the proposed purchaser's use of the land, may be. You'll see there's reference then, the first page under the judgment of Mr. Justice Wilson, to the lease, which was executed in 1965, 20-year term, under which Crej held the lands in question. Over the page, we can see the lease and the restrictive covenant in question. At the bottom of the page, Article 18, the landlord had covenanted that within the confines of a particular site as identified, as we can see at the bottom, it would not allow its land or property to be occupied without the permission or the prior written consent of the tenant. And then perhaps more significantly, the next paragraph, the landlord further covenanted that in respect of the area outside Exhibit A, but within a 3-mile radius thereof, it would not permit the lands to be used for the sale, lease, rented, or used or occupied for the operation of a department store, and various other types of trade are identified. Just turning over the page again to the end of the lease. It's noted these covenants, I was told, were part of the factors inducing Crej to execute the lease, and that had since been assigned, but that was not relevant because BACM was still subject to its personal covenant. BACM was proposing to sell the lands to Cowell. You see at the bottom of the page, Cowell was proposing to develop a shopping area, and that evidently was going to, if constructed, be in breach of the lease. The analysis in relation to the defence of restraint of trade, you'll see set out 3 pages from the back of the judgment. In the middle of that page, 371. There's pagination top right-hand corner, my lord. Page 371, the centre of that page. All covenants in restraint of trade are prima facie void at common law, and then there is the consideration of Nordenfelt and some of the other...
So when Dr. Hayden, in his article and book, say there has been an assumption made that this sort of case is within the doctrine and courts go straight to reasonableness, is this an example of that?
Strangely, my lord, this case does not engage with ESO. So the cases that are cited are...
But does it engage with, is the doctrine applicable at all?
Well,
or does it go straight to reasonableness?
In essence, my lord, it goes straight to the question of reasonableness.
Yes.
But,
so how helpful is it to us?
well, the only way in which it may be considered helpful, my lord, insofar as at least the respondent is concerned, is that the court had no doubt and was prepared in going to reasonableness to accept that the restraint of trade doctrine was engaged.
Yes.
And if one is looking then for an authority insofar as a landlord is concerned, a developer landlord in this case, it rests
Yes.
appropriately with the present case.
I mean, it is an interesting case, because I think it's the only example we've been shown of a case which is comparable to the present one, but frustratingly they didn't seem to discuss the question of the applicability. But I do see on page 372, they talk about the shopping centre cases, and there's a sort of implication that this may be a line of authority, I don't know.
Well, it simply notes the contest touched on the right of one store to Bangor, the carrying on of the same centre of a competing business. So,
I don't know, well, we can have a look at that and see if there's anything there. But, I mean, this is helpful because it's to you, because it says, well, it assumes that it applies, but for our purposes, it's not helpful in the sense it doesn't say why. So.
well, the next case, my lord, the court may feel certainly is more helpful, at least in terms of analysis. That is the McDonald's case versus West Edmonton. That's a decision of the High Court in Alberta. Mr. Justice Mason handed down judgment. The plaintiff was McDonald's, see that at paragraph 1. It was seeking an injunction to restrain the defendant, which was West Edmonton Mall, called WEM, from permitting the operation of a restaurant within its mall in breach of a restrictive covenant between McDonald's as tenant and WEM as landlord. So again, we have a case in which the landlord had entered into a restrictive covenant and which was being relied upon by the tenant. We can see the covenant is then set out, paragraph 2, in the lease. The landlord covenants and agrees with the tenant. The landlord covenants that it shall not occupy, use, or lease the servient lands, or suffer or permit the servient lands to be used for the operation of a fast food restaurant. So the landlord, a developer, or certainly landlord occupying the site, was covenanting that it would not suffer or permit its land, its site, to be used for a fast food restaurant, which would be in competition with McDonald's.
That's limited to 20 years.
It's limited to 20 years, yes, my lord. And we can see that a separate agreement then was entered into. In fact, in addition to the lease of paragraph 3, the landlord in that agreement acknowledged that the restrictive covenant was one of the basic conditions of the tenant entering into the lease, and further, the landlord acknowledges that the terms of the restrictive covenant are reasonable. So that was, as it were, to copper fasten the position in respect of the lease. Now, what then happened, we can see set out in the facts. They're set out at paragraph 7. Recites again the fact that McDonald's had entered into the lease in respect of a portion of the West Edmonton Mall, known as Phase 2. The negotiations of that are set out at paragraph 8. The director of McDonald's in Western Canada negotiated the business terms of the lease with the vice president of WEM, Mr. Garmazian. The detailed terms of the lease were attended to by the respective solicitors. And what McDonald's were saying was they required a restrictive covenant to prevent another restaurant coming into the second phase, or Phase 2 of the mall, and competing with McDonald's in its primary business, which was the sale of hamburgers and chicken. Again, my lord, one can see all sorts of parallels to the present case. McDonald's was committing itself to a large capital investment and a large ongoing rental obligation to put the restaurant into the mall. Therefore, it wanted the protection of a restrictive covenant. And that was agreed to, as we can see, by Mr. Garmazian of WEM. McDonald's registered a caveat in the Land Titles Office to protect its interest under its lease. And we can see McDonald's then commenced trading from about 1983. It opened a second restaurant in 1985, and again a separate covenant and identical lease was entered into. So it then seems at paragraph 11 in 1993 that McDonald's became aware that Johnny Rockets was going to be coming to the West Edmonton Mall. And from that, we can see in the subsequent pages a series of correspondence and issues were raised. And we turn then to what issues then arose when litigation commenced. The first issue does not really have anything to do with the present. That was a question of construction, what the restrictive covenant meant, and was an analysis of whether or not Johnny Rockets were in reality going to be in competition with McDonald's. But the second offence is much more significant, and that starts at paragraph 37 of the judgment. The second offence which was raised was the enforceability of the restrictive covenant, and that, submitted by the landlord, was a restrictive covenant, and the contention then advanced, as we can see at paragraph 38, at the second sentence. What was raised and what was argued by WM on this point is that the interpretation of the restrictive covenant sought by McDonald's goes far beyond protecting McDonald's legitimate business interests and is prohibited at law by the restraint of trade doctrine. And then they discussed the various interests of McDonald's and WEM. We can see in paragraph 39, the argument is based on the restraint of trade doctrine. Some of the authorities, including Nordenfelt, are set out. Paragraph 40, two basic questions are raised by WM's argument. That the restraint of trade doctrine should apply to the interpretation of this restrictive covenant. Is the covenant one which is in restraint of trade? And if so, such a covenant being prima facie unenforceable, can the restrictions be justified as being reasonable? And Esso Petroleum is cited in that respect. Paragraph 41, restrictions placed on a parcel of land by a person who owns or occupies these premises, such as in this case, fall within the restraint of trade doctrine, see Esso Petroleum. Well, that, my lord, is Lord Reid's test. In this case...
That's all he says about it.
Of course, my lord, yes. But unsurprisingly, I suppose, my lord...
Frustrating, you're sort of building up.
Yes, you've got us quite excited.
I'm sorry, my lord, I can't do much about that, but I can say this, my lord. Insofar as the test was concerned, it in fact doesn't seem to have troubled the court at all to draw the conclusion that in that case the landlord, BACM, was giving something up, notwithstanding, my lord, the obvious detailed nature of negotiations, close involvement of solicitors, and the drawing up and indeed execution of a separate agreement in which it was accepted by BACM that the provisions were reasonable.
Because would you agree with this, that the essence of the reason for the restraint of trade doctrine is that it's not right to have restrictions on competition to protect someone? So that in this case, McDonald's couldn't impose a restriction on what was effectively a restriction on competition with them through this means.
The purpose of the covenant was to protect McDonald's trade, and in parallel, we say to the present case, the purpose of the restrictive covenant imposed or sought by Duns was to protect their trade.
But the essence is unnecessary restrictions on competition.
Yes. But
so if one thinks of it as a two-stage test, would you say that it was wrong to think of it in terms of applying only to what can narrowly be described as a trade as opposed to a business, that it has, the categories are not closed, but that within that first question there might be some question of thinking about an unnecessary element of the restraint on competition at the first stage?
I certainly, my lady, would say that the categories of trade are broad in scope, and whether trade or business, the definition of trade, we would say, is wide. And in that context, where one has trade affected or competition between businesses engaged, one therefore engaged the doctrine. What this authority says, there was some debate yesterday about whether or not the two parties had to be in the same trade. So did you have, as in some of the antiquated examples, one baker letting a property and covenanting that he would not engage in the trade of baking in the same district? But this case shows, my lady, is that BACM as developer, it was never going to be running a fast food restaurant. It itself was not going to be engaged.
BACM is clearly in your favour.
Yes.
And the point that's being made is, well, a developer's business is not the same as any other business, and so that's the line. But what is frustrating about this judgment is we don't get any help as to what, if any, arguments Mr. Redmond QC put forward on behalf of McDonald's for against the SO analysis.
Yes, I accept that, my lord.
But it does clearly discuss a two-stage test. And what I'm putting to you is that the scope question, question 1, must not be construed narrowly. And I think you
Yes.
agree with that. But that also it has within it an element of a value judgment. If you go to paragraph 40, line 3, the first question is asked, is the covenant one which is in restraint of trade? And I think you say yes, because it was restraining competition. Doesn't matter between whom, but it was restraining competition. And then it goes on, and if so, such covenant being prima facie unenforceable, can the restriction be justified as being reasonable? Now, if within the first question, the scope question, there is also an element of whether the covenant is prima facie unenforceable, then there is an effective restriction, is there not, on the sort of cases that will run foul of the restraint of trade doctrine?
There can be, yes, my lady, because the doctrine will not be engaged in every case. So subsumed to an extent within the question, is the covenant one which is in restraint of trade? There is a value judgment to be made. Is this one which is affecting or impacting upon trade? And
looks to be unnecessary.
Sorry, my lady.
And looks to be unnecessary, because we know some restrictions are part and parcel of doing trade.
Yes.
But some are unnecessary restrictions that have been imposed to give unfair protection.
And where the unnecessary restriction is engaged, one then calls upon the party seeking the restraint to justify.
That's
Yes.
right. So it's a two-stage test, but there's more in the first stage than simply saying, is this a trade or a business?
Accept that, my lady, yes.
Yeah.
Of course, if we're to look at it in terms of competition, I suppose we shouldn't forget the 1998 Act, which you did invoke, and then realised you couldn't get home on it.
My lord, we say that that does not assist because, as it turns out, the evidence submitted, in fact, by Duns demonstrated that neither party had market power, and therefore neither party engaged the protection of the Act. So one of the points we make in our written case, it's a bit much of Duns to say to us, will you have the protection of the Competition Act, when their own case was, it's not engaged.
Yeah, okay.
Does the Stevens case shed any light on this?
Sorry, my lord?
Does the Stevens and Gulf Oil case referred to at paragraph 40 shed any light on this?
That's in the bundle, I think.
It is, my lord. I don't think it adds a
It
great
does
deal
really, no.
of assistance, certainly in relation to the point we are seeking to advance, which is a developer, someone in a different type of trade. Stevens and Gulf Oil is another example of the SOLAS type agreements in relation to petroleum.
Thank you.
So yesterday, my lords, as I was dealing with the pre-existing freedom test, we became engaged to some extent in the discussion of what cases there were in Australia. And moving then from Canada to the other side of the world, can I ask, my lords and lady, if you could turn to volume 4, tab 50. And this is a decision of the Supreme Court of South Australia, a case called C Convenience Stores versus Wavell.
Page?
Page 1100, 1100. The facts are set out at page 1103. I'll try and deal with those quickly. The plaintiff was C Convenience. It was proposing to sell land, a set of paragraph 1. C Convenience, just as we note at paragraph 9, also was connected to another group of businesses, among which was one running a fuel sale business called On the Run. So the vendor of the land had attached to it or connected to it a trading business. It was seeking to sell the land to the first defendant, Wavell, referred to as WPR, and the expectation was that that sale of land would complete in June 2009. It didn't as a result of the global financial crash. C Convenience then was suing WPR for breach of contract. Liability was denied. It seems that the defendant, purchaser, and the guarantor, they didn't deny the claim in the sense that they accepted there was a contract, but what they said was the contract contained within it unenforceable covenants which are unlawful restraints of trade. You can see that at paragraph 5. We turn then to page 1106, paragraph 26 of the judgment. We can see the restrictive covenants which were contained within the sale agreement.
Sorry, page.
1106.
Thank you.
Paragraph 26 of the judgment. The contract contained a number of special conditions. One of those in particular is relevant clause 11. It's set out at paragraph 27, and by it, the prospective purchaser was covenanting that it would not use the property or allow it to be used when purchased for a variety of different businesses, and they are set out over leaf, service station, vehicle washing, and so forth. Those, of course, being businesses which it was considered may compete with other businesses connected to the vendor on the run. We can see at paragraph 30 then there was a provision in relation to consideration for the restrictive covenant, expressly recording that there was an additional payment being made in respect of the purchaser entering into these covenants. Clause 11.3 contained a specific acknowledgement on the part of WPR that it acknowledged and agreed the provisions set out in the special condition 11 we just looked at, were for the benefit of the purchaser and his successors in title, enhance the genuine amenity of the property, and are reasonably necessary and expedient to protect and benefit the trade carried on upon the dominant land. We then can go to page 1111, where the general principles of restraint of trade are set out. I just note that in passing. I don't intend to take my lords through them. They are well traversed. And then, significantly, to page 1114, where we see the first issue being addressed by the court, that is the application of the restraint of trade doctrine. Paragraph 59, the observations of Lord Pearce in Esso are set out. The observation being made that in terms of drawing a line between those contracts which are in restraint of trade and whose reasonableness can therefore be considered by the court, and those which merely regulate the normal commercial relationship between the parties, well, the observation is, as concluded by, as well, the court in Australia, it's not always easy to define that line. Paragraph 61, the covenants in question were considered and their practical effect. The reason they were sought, paragraph 62, was to protect the other business connected to, see convenience, the vendor. And then, if I take my lords to the analysis in terms of restraint of trade, turn to page 1122, paragraph 99 of the judgment, we have the consideration of Esso. The tests of Reed, Morris and Hodson are set out, and the two other tests, Lord Wilberforce, Lord Pearce. Take my lords then over the page. Top of page 1123, we see Lord Wilberforce's Trading Society test set out. Then Lord Pearce's sterilisation of capacity is set out. And just dealing with this point now, my lord, you will see there the reference to Lord Pearce's test being disapproved in Australia by a decision of the High Court, Peters WA Limited versus Petersville. You do have that judgment in the Bundle of Authorities of Volume 2, tab 29. I don't intend to take the court to it. But what that case did was it specifically and expressly determined that, at least in Australia, that the sterilisation of capacity test would not apply. Moving over to paragraph 104, consideration of Peters again is undertaken. You'll see the decision of the majority in Peters. The majority noted criticisms of the pre-existing freedom test, noted the adoption by the federal court, full federal court, in the case of Australian Capital Territory versus Monday, which we saw yesterday, of the Trading Society test, and the majority refrained, however, from expressing a concluded view. So what the High Court of Australia has said is this: sterilisation of capacity test does not apply. Lord Reed's pre-existing freedom test, they noted the criticisms, but they declined to reach a concluded view as to whether or not it was appropriate. There does then seem to have been in Australia a preference adopted, certainly by the lower courts, of Lord Wilberforce's Trading Society test. So, if we turn then to paragraph 108, page 1125, the court then goes on to consider the trading society test in the present case. It's noted that does not mean the fact that WPR has had no prior interest in the land and was in a sense a volunteer is immaterial, because of course under the pre-existing freedom test, this was a purchaser coming to the land subject to a condition or covenant imposed through the contract. But in applying the trading society test, that question of what pre-existing freedom you're giving up does not arise, although the court considered it may be something that is relevant, but it does not operate by itself to exclude the operation of the doctrine of restraint of trade. So then the application of that test is considered, and you'll see it 110. It is the essence of the trading society test that its application to exclude the restraint of trade doctrine will depend upon the circumstances of each case. In other words, it is fact-specific. It involves the courts excluding from the doctrine such contracts or provisions of contracts as under contemporary conditions may be found to have passed into the accepted and normal currency or commercial or contractual or conveyancing relations. Again, its application involves conclusions of fact on the basis of the evidence adduced. There then is a reference to a case called Specialist Diagnostic Services versus HealthScope. We're going to look at the appeal of that decision in just a moment. But what then we can see set out at the bottom of paragraph 111, the same principles should apply in the present case. It is C, convenience, which makes the positive assertion that the restraints of trade contained in the restrictive covenants are outside the doctrine, and there is some overlap between the matters relevant to the application of the trading society test and proof of matters going to reasonableness of restraints. And that was precisely, my lords and lady, the point I made yesterday. The trading society test imports into the assessment of what is a threshold the question of whether or not it is reasonable. However, perhaps is of some significance, if one were to apply it to this case, the burden or the onus of proof falls upon the party which is seeking to impose the restraints of trade to demonstrate not only the reasonableness, but that they are outside the doctrine. We then have an observation simply of the facts in that case. C, convenience, adduce scarcely any evidence to discharge its onus, and in those circumstances, it was held, I consider that applying the trading society test, the restraint of trade doctrine is applicable to the restrictive covenants in that case. So, restraint of trade applies, engaging the trading society test, because in that case, the court, on the evidence before it, was not satisfied that C, convenience could demonstrate that this particular covenant were of an accepted standard which falls within the body of contracts or conveyances or leases that one might expect to find. The most recent decision then in Australia is the appeal decision in HealthScope. My lords will find that in volume 2. Well, my lords, I should say, the most recent case of which we are aware is the decision in HealthScope. And if I take my lords and lady to volume 2 and tab 33, you'll find that judgment set out. This is a decision of the 8th of August 2012.
Sorry, did you give us the page?
Sorry, my lady, it's page 658. So this is a decision of the Court of Appeal of Victoria. Take my lords and lady to page 660. The facts are relatively intricate, but in my respectful submission may be considered important. There were 3 hospitals set out at paragraph 2. They were owned through wholly owned subsidiaries by the main group, paragraph 3. The appellant was a firm called Symbion. It provided certain pathology services, a collection service, a collection centre and a testing laboratory. It, in November 2003, leased premises in the 3 hospitals in order to carry on its business. And when it entered into those leases, they contained a restraint of trade, and that restraint of trade was imposed again upon the landlord. And it was simply that the landlord should not, as set out paragraph 6, become directly engaged in a similar business to that of Symbion. And we can see then over the page at page 661, it did not restrict the landlord from engaging in activity in which it was then currently involved. So the effect of the covenant within the lease was that the landlord was restrained from, at some future point, either carrying on or be concerned or involved directly or indirectly in a business or trade similar to that of Symbion. We can see the leases then in the 3 hospitals are set out paragraph 7. They're all for approximately 20 years. We can see at paragraph 9 that the owner of the hospitals, the main group, at the time it was entering into the lease, had already announced an intention to sell the hospitals. Paragraphs 10, 11 and 12, the services undertaken by Symbion in the pathology labs at the 3 hospitals are referred. And then, in paragraph 13, we can see that Healthscope, which was the first respondent, it purchased the business and land of the 2 of the hospitals, and the 3rd it acquired the shareholding. So, in essence, Healthscope succeeded and became the owner, through one mechanism or another, of the hospitals. But what it then did is set out at paragraph 14. It then acquired 2 other pathology service companies. Gribbles is one, the second is referred to as DCL. And then, having acquired those new businesses, it, as landlord or party standing in the position of the original landlord, it then leased those premises in the hospitals and started to operate through those businesses pathology labs. And the consequence of that is set out at page 663, paragraph 18, where the Symbion's business was very substantially damaged and shut down in 2 of the hospitals and was significantly reduced at the 3rd. Now, there were a range of issues which came to light. The judgment you will find at first instance set out at page 665, paragraph 21. Symbion had brought proceedings alleging they had breached the clause, had derogated from the grant, but most significantly for the purposes of this case, the respondents for their part contended that the clause in question was unenforceable as it was an unreasonable restraint of trade. So
I've got a bit muddled about the facts. I thought that the covenant was, we won't open any pathology services in these hospitals.
Yes.
And I thought that what Healthscope did was to open pathology services, not in the hospitals, but adjacent to them.
Well, what it did, my lords and lady, it, in the hospitals, opened a pathology lab, which in one, paragraph 15, in one hospital was connected to the hospital, so there was a tubular vacuum delivery system which enabled samples to be transferred. In the second hospital, DCL was operating from premises located in consulting rooms within the same building, albeit...
I see. So there was a bit of pathological trade in the hospitals.
Yes.
Very well. Thank you.
And at first instance, page 665, paragraph 22, the second sentence, third sentence in fact, the judge at first instance, His Honour held that the clause was invalid as the restraint of trade doctrine applied to it, and the clause was unreasonable both in time and in terms of geographical extent. Can I ask my lords then and lady to turn to page 672, paragraph 51 of the judgment.
Yes.
Grounds 3 and 4 are set out of the notice of appeal. The first was that the trading society test, if applied, meant that the doctrine of trade should not apply to that clause. And secondly, a separate point, that there was no basis on which the clause should be invalidated where it was the Healthscope choosing to purchase land which was already subject to the restrictive covenant. Paragraph 52, it is well established there are some species of restraint of trade which do not attract the operation of the common law doctrine. Symbion in paragraph 53 submits that the restraints fall within a category to which the doctrine does not apply. It was submitted that within commercial leases, exclusivity provisions of this type and issue are accepted practice and fall within the trading society test formulated by Lord Wilberforce in Esso. That set out. We then can see the postulation of the three tests again in Esso and considered reference to Peters and Petersville again, the rejection of Lord Pearce's sterilisation of capacity test. And we say, my lords and lady, that was as far as the High Court of Australia in fact went. Paragraph 56 then, the court then proceeded, for present purposes, it is sufficient to deal with Symbion's arguments on the assumption that the trading society test applies. Before turning to its application, and this is, my lord and lady, perhaps the point of greatest significance, if we're looking at the application of the trading society test, how, in fact, it is applied in practice. And in this case, the first point noted is it removes restraints of trade from examination by reference to the common law rules in a provisional way only. Why is that provisional? Well, because, firstly, that the trading society test must have a protean quality which evolves as social and economic circumstances change. It's not a fixed test, it is one that may change and therefore needs to be looked at carefully as each case comes before the court. Secondly, even within its own formulation, the test accepts that a restraint will fall to be examined if in an individual case there is a greater than usual restraint. Now, one of the issues discussed yesterday, my lords and lady, was the question of this covenant in this case that Peninsula is now subject to, and it is evident from the lease that it extends for 999 years. Now, there may be other issues that arise in relation to it, but taking length on its own for the moment, length of itself undoubtedly can represent sufficient to invalidate a covenant as being restraint of trade, and the proof of that submission is Esso itself. One solus agreement in relation to one garage in identical terms to a separate solus agreement in relation to a second garage held by the same party. One was upheld ultimately because it was only for 5 years. The other was struck down because it was for 21 years. So our submission is this, that in relation to length alone, that if it is outside the norm, if it is beyond what would ordinarily be expected, that may well be sufficient ultimately to strike down the entire covenant.
Why the entire covenant? I mean, if it's reasonable to have a 21-year covenant but not have a 999-year covenant, can't you declare that?
The court does not rewrite the covenant. It's either there is provision, except for severance, and there may be an interesting debate as to what that may mean if we ever get to that point in this case. But we're at the threshold stage at this stage, and in my respectful submission.
Well, that's the assumption that we're applying the sort of that approach. But if we're moving to a trading society test, whatever that means, then one aspect of it may be that you can cut down, if it's purely length of time, that you would cut that down to a reasonable length of time.
Well, I'm not sure I quite follow. If we use the trading society test, my lord, we say on the facts, in fact, of this case, that the evidence is not there to demonstrate, to satisfy the court, that this is not a greater than usual restraint. And if that burden has not been discharged on the evidence, well then, even if one applies the trading society test, this case, Peninsula, engages the threshold.
Lord Carnwell says you're trying to have your cake and eating it. If you want the trading society test, you must look at what is acceptable and normal in terms of a trading society and accept that result.
Of course, my lord. But what is acceptable and normal in a trading society is a question of fact. And that question of fact is one which has to be addressed by evidence, and the evidence of what is acceptable and reasonable and appropriate.
Yeah, but you're missing the point. I mean, you're now on the length of it, and I can see that 999 years seems pretty absurd. But really, we want to look at this case in terms of what would be a reasonable length of time, if that's where you put it, simply to see what the principle is.
Yes.
I mean, it'd be rather unsatisfactory if we simply decided this case is on the basis that 999 years is too long, but 21 years would have been acceptable.
My lords, my submission would be this. The purpose of it is to allow the Duns in this case to recoup the investment it incurred in constructing the store. So over what period of time would Duns reasonably seek to recoup its
No, I
investment?
understand that. I mean, you've got your point, but
Yes.
we're trying to look at this as a matter of principle, not just in terms of the length of time of this particular covenant.
My lord, I'm not sure.
Oh, sorry. Shall we go back to this case? I diverted you.
Well, my lord, my only point is this, that as a matter of principle, on the threshold question of whether the doctrine is engaged, the court does not need to engage with what is reasonable, because that is a question that goes to the question of justification. And a justification, Duns might say, it's perfectly reasonable to have this length, and we might say, well, it might have been reasonable to have 5 years or 10 years or even 15 years, but not 999.
This goes back to the point I was making about the threshold test being more than simply determining is this a trade or business, which is being, and is there a restraint on competition? Because if there is a evaluation in there of whether the restraint is prima facie unenforceable, I think it was put in your case, or unnecessary, that is simply a short kind of exercise for the court at the preliminary stage, such as the court has often on a threshold test, to make some kind of evaluation, and then opening the door if it finds that there was an unnecessary or greater than usual restriction, then to allow the court to remit the matter for the purpose of reasonableness and justification.
Yes, my lady.
To be justified.
So how does it all end up in this case?
Well, my lord, paragraph 59 then, there was a submission which was advanced then. The court accepted that there was a well-established line of authority for the proposition that relating to the restraints of land do not ordinarily apply to restraints acquired by a party acquiring an interest in land. So someone coming to land acquiring an interest would not ordinarily be subject to the doctrine. Turning over the page, quadrimain is addressed, but importantly, having looked at quadrimain, the Court of Appeal says in paragraph 61, it does not follow, however, that simply because a restraint relates to land, that it will not be subject to the rules governing restraint of trade, unless it was cited as authority for that. And that was to deal with the second point of appeal, which has been brought, that in the particular facts, there was no engagement because this was a lease. Also, perhaps again significantly, nor does it follow that a landlord is necessarily to be regarded in the same way as the lessee. A distinction has been drawn between the lessee, who comes to the site, and the landlord who is there, who owns the site, and is, if one applies Lord Reed's test, giving something up. We see at paragraph 64, it may be accepted ordinarily the aliener of part of land may be able to bind him or herself with respect to the use of the balance of the land. Symbian submitted that those were common type provisions in other examples of shopping centres or standalone facilities. But, paragraph 65, we were not, however, referred to any persuasive authority which extends the postulated exception from the restraint of trade doctrine to all covenants in restraint of trade made by a landlord. So there could be no authority cited by Symbian to exclude the landlord covenants from the trading society test. In fact, Hind versus Gray, which was the judgment we were provided with yesterday, says quite the contrary, because in that case it was the lessor who had entered into a covenant, and that, applying the decision in Ward and Byrne, was struck down because it was too wide in terms of space. Over the page 667, ACT and Monday is referred to, and the conclusions of the court on that are set out at paragraph 69. The court concluded that the trading society test should be applied and that the restraint of trade doctrine had no application to the terms of licenses. And interestingly, of course, my lord, the view in relation to that at paragraph 70 is that the conclusions drawn in that case turned on the particular character of the transaction. That was the case involving someone coming to a dump and seeking then to practice on a fairly limited scale a business in scavenging. But they were entering the dump on foot of a license, and the view expressed, at least in health scope, those principles cannot be extrapolated to apply in some generic way to obligations imposed upon a landlord under a lease, particularly in circumstances where those obligations purport to extend beyond the landlord's tenement. So the trial judge was considered correct to conclude that Monday did not justify the conclusion of the grant of an exclusive licence to a conduct of business will always satisfy the requirements of the Trading Society test. And again, we see, in terms of the application of the test, in similar vein to the last case, as His Honour recorded, first instance, there was no evidence before him of accepted practice relating to restraint of trade provisions in tenancy agreements concerning pathology facilities within hospitals. And in those circumstances, in the absence, essentially, of evidence, the court then could not, at paragraph 73, with respect, accept that there is authority which justifies the postulation of a general exception with respect to restraints of trade comprised in a landlord's covenant under a lease. And then 4 reasons were given by the court as to why the doctrine should be applied to the particular covenants in the lease. Firstly, it extended beyond the land retained by the landlord. In other words, it was too broad in scope. Secondly, even where the covenant contained in the lease is reasonable as between the parties, questions of public interest might arise in respect of the impact, in that case, on medical services. Thirdly, there was no acceptance of accepted practice relating to restraint of trade limitations in respect of covenants given by hospitals. In other words, evidence had not been presented by, to the court to demonstrate that this was a part and parcel of a trading society or was not outside the normal run of those type of covenants. And finally, it was considered that in any event, the provision in question went beyond the type of restraints commonly embodied in exclusivity provisions in commercial leases, and therefore would fall to be examined under the proviso to the Trading Society test. In other words, it is possibly within the general principle that these covenants should be there, but this one goes too far and therefore should be examined under that proviso. So, my lords and ladies, what we say those cases demonstrate in relation to the Trading Society test, when applied, if one were to do so to the facts of the present case, there is no evidence that this particular covenant is common or part of an accepted standard. Length of itself or duration is sufficient based on ESO to establish that a covenant is a restraint of trade. And insofar as if the appellant is relying on the trading standard test, the onus is on it to satisfy the court. It is part of the accepted practice and it does not fall within the exception. So what we say also, my lords and ladies, is one further point. If you step away from the pre-existing freedom test and apply the trading standard test, it doesn't matter whether it's Peninsula or it is Mr. Shorthall, because the question then is not, did Peninsula give up a pre-existing freedom? The question is this particular restraint imposed upon it one which is required to meet the reasonableness test? The threshold question, therefore, which perhaps examines so much of the consideration of the Court of Appeal on ESO, of whether or not there's a pre-existing freedom, completely falls away if one adopts the Trading Society test.
And here we did have evidence that covenants of this kind were not uncommon, although not necessary for 999 years.
Yes, exactly. So we would not demur from the principle. Of course, it is common to have a covenant imposed, and no one could complain that done
to protect a tenant like,
but not that period of time.
I see. So can I just note that down? You would not. What are you conceding?
I would not demur from the proposition that a tenant such as Dunn's might seek a covenant from the landlord restricting the other units or the other businesses which would be brought into the shopping centre. But what, of course, I do say is not for 999 years.
And would that be because it satisfies the trading test, or because it satisfies the reasonableness, or it doesn't get over the threshold?
Well, it's outside the accepted standards. Yeah. That's the first point.
I mean, no, so the one that you would accept, I mean, I understand your position on the 999 years, but in relation to the one you would accept is okay, would that be because it meets the trading society test, or because it meets the,
Well, it would,
or it doesn't get over the threshold?
certainly meet the trading society test. It may, on one view, on the pre-existing freedom test, the landlord would have given something up, but the landlord would recognise that it would fail to establish at the next stage that it was one which was unreasonable.
It's the second stage, you say.
And even if you get through the first stage, they could always have a trial of the second issue.
Yes.
And may succeed.
In which case the landlord would be visited with costs.
And which test do you favour?
In our written case, my lords and lady, we make the case that let sleeping dogs lie. The pre-existing freedom test has been there now for over 50 years. It is a test which has been applied broadly, particularly within this jurisdiction, and to that extent we say stick with ESO and Lord Reid's test of pre-existing freedom. But in light of the case developed yesterday by the appellant, if one were to go down the trading society test, we say it doesn't actually matter. We still trip or cross that threshold. Can I then move, my lords and lady, hopefully quickly through the Tulkin-Moxey issue? A number of points we make in relation to that. The first point is we say this is a leasehold covenant. The court has already been referred to the lease. The lease is registered as a burden on the land certificate, and therefore, in enforcing it, it will be enforced through the lease. And as a leasehold covenant, it is subject to DC's Act. The judgment of the Court of Appeal, we would respectfully submit from paragraph 50.
You say it's a leasehold covenant.
It is.
It's a covenant by a leaseholder.
It's a covenant contained within a lease.
Yes.
And it imposes, through that lease, an obligation on the landlord. And through DC's Act, there is an automatic transfer to the...
I would have thought it was a freehold covenant in a lease. I mean, there's a reference, when I read the judgments, particularly of the Court of Appeal, oh, this is all about a leasehold covenant. I said to myself, that's a funny description. It's a freehold covenant, isn't it?
Well, my lords and lady, we say it is a covenant within a lease. What is registered on the lease, or what is registered in the land certificate, is the lease.
Of course.
And one goes to the lease to see where the restrictions engaged.
Of course.
And the fact that the land is land registered and freehold land is neither here nor there, in the sense that where the covenant is to be found is within the lease, and that the lease within itself contains a positive obligation that when the landlord assigns or passes on his interest, he must ensure that the successor in title...
Oh, well, it's only a label. This is a leasehold covenant, albeit not by a leaseholder. Can I write that down?
Sorry, my lord.
This is a leasehold covenant, albeit not by a leaseholder. Can I write that down? As your
Lord, it's
submission?
a leasehold covenant in which the lessor, the party who now stands in the position of landlord, is Peninsula. It acquired the title of Mr. Shorthall, and it now stands as landlord to Duns.
Okay.
The point, my lords, given the time, I don't propose to take you through the paragraph 50 to 53 of the decision of the Court of Appeal, save to say that what the Court of Appeal, well, if my lords wish me to, it's page 1617, it's the core volume.
Sorry, just before, I mean, the DC's Act, which you know all about,
Yes.
at least I don't, is relevant in the sense, remind me why that comes in.
Provides a statutory mechanism of passing on the lessor's obligations and burdens and the lessee. So there's two sections, the effect of both of which is respectively to...
I think we were told that these are enforced as pure contracts, not as estates and land.
Well, yes, they are enforced through contract, yes.
And so one then goes to DC's Act, which tells you how they
Pass
pass.
on.
And it's a leasehold covenant in the sense that it has to be one of a landlord and tenant relationship to be within DC's Act at all.
Yes.
So,
Well, Lord, my submission is it really doesn't matter whether it's freehold or leasehold. And
no, but it's
Tulkin
quite
Moxey
important we get it right.
yes, I accept that. It is a red herring, as it were,
Yes.
the Tulkin-Moxey principle at all.
But DC's Act applies only to leasehold covenants,
Yes.
is that right? And How is that defined?
How is DC's Act defined? Well, you have DC's Act.
If there is an issue as to whether this is a leasehold covenant or not.
Sorry, my lord.
If there is an issue as to whether this is a leasehold covenant or not, don't we need to know
I don't think
whether
there
it
is. I think it's common ground that this
whether it falls within the Act or not?
Within DC's Act, which we have, it's a primary volume, volume 1, tab 4. Section 12 deals with the landlord, and that the landlord of any lands under any lease or other contract of tenancy shall have the same right of action or remedy against a tenant and the assignee of his estate or interest or the respective heirs, executors or administrators, as would have been held by the original landlord. And then over the page, Section 13 effectively applies to the same position. The tenant has the same right or action against the landlord and assignee as they would have had against the original landlord. It largely, my lord, in terms of leasehold, reflects what happens in Tulkin Moxey, where equitably the burdens pass on as long as the party coming to the burden had notice of it and was aware of it. But in terms of the doctrine of restraint of trade, what the Court of Appeal found in their judgment, Mr. Justice Stevens, Lord Justice Stevens, at page 1617, it's within the core volume, internal pagination 16. Two questions were posed at paragraph 50. Firstly, A, the question whether the burden of restrictive covenant can be enforced against an assignee of the covenantor, which depends on DC's Act, and in other cases may depend upon the rule in Tulkin Moxey. And B, the quite separate question as to whether the freehold or leasehold restrictive covenants are subject to the doctrine of restraint of trade, which applied or is subject to the acid petroleum test. And 51, they say the answer to the first question is straightforward. Section 13 of DC's Act provides the benefit of the agreements and leases or tenancy agreements can be enforced against the successor in title. And the court considered that the burden of restrictive covenant can be enforced against the appellant, my client Peninsula, under Section 13 of DC's Act. In respect of the question of freehold lands, that would depend upon the rule in Tulkin Moxey, but that didn't arise, the court considered, because the option was open to impose in any event through the lease. The more difficult question perhaps then is in relation to whether they are leasehold or freehold. It doesn't matter in terms of the application of the question of restraint of trade. Whether you are a lessee or lessor subject to a covenant when first entering into the lease, or there is restrictive covenant subject to Tulkin Moxey, the question is whether or not the person has given up, if one applies Lord Reid's test, a pre-existing freedom. So one would not see a different position just because you were a lessor giving up a pre-existing freedom than a vendor transferring an interest subject to some form of covenant. So that, in our respectful submission, really means that Tulkin Moxey doesn't add anything to the case at all. It's interesting that that has, as it were, developed into in particular, the Australian jurisprudence through the decision of Quadramain, when in Esso Petroleum, the decision of the House of Lords, there's no mention or citation of Tulkin Moxey at all. If one applies the pre-existing freedom test and therefore is satisfied that the doctrine of restraint of trade is engaged, there's no reason for conflict between the doctrine of restraint of trade and the rule in Tulkin Moxey. If you're giving up a pre-existing freedom, that has nothing to do with the nature of your interest in the land. And in any event, we say, my lords and lady, there is in fact no conflict between the two. If I can briefly just take the court to Tulkin Moxey, which is at volume 2, tab 24, page 479. The test is set out at page 480. see a 778 pagination in the middle of the page, then it is said that even the covenant being one which does not run with the land, this court cannot enforce it.
Sorry, were you reading?
I'm just reading the test. You'll see a 778 in
Yes.
bold. Just above that, 2 lines, it is said, this is the, captures the Lord Chancellor's definition of the proper test. But the question is not whether the covenant runs with the land, but whether a party shall be permitted to use the land in a manner inconsistent with the contract entered into by his vendor and with notice of which he purchased. Now, if a covenant is in restraint of trade, then it is unenforceable. The contract on which that covenant is imposed cannot be enforced. And if the vendor can ignore it, in other words, say, you might have the benefit of that covenant, but I am not subject to it because it's unenforceable at law as a restraint of trade, why on earth should the successor in title then be subject to the unenforceable contract which could not be applied against the vendor? And the final point we make, my lords and lady, is this. If the court felt that there was some conflict, then assuming for the moment that the covenant is in restraint of trade, and therefore that covenant is offensive to public policy, we say the doctrine of restraint of trade must prevail over the rule in Tulkin Moxey, if the court is satisfied, as we say, at least on a prima facie basis, that on a public policy issue, this covenant may be in restraint of trade. Can I then, my lords and lady, move briefly, I hope, to deal with the alternative remedy point under the property order? That argument, of course, in the context of this case, must be developed on the principle that the threshold test is not met. So it has to be applied at the question of threshold. We can make a number of points. Firstly, there is no authority cited to support the proposition that if there is an option for some form of alternative remedy, that the threshold is not met. Whether one adopts the pre-existing freedom test or the trading standard test or indeed any other test, all that does is add an extra dimension to the test. Because one has to ask, well, is there or is there not an alternative remedy? If there is a question over whether there is an alternative remedy, well, one must assess then, in looking at the threshold, is it an effective remedy? A doctrine of restraint of trade based upon public policy, there would be little benefit in saying, well, you have some form of remedy, it may not be one that's in any benefit to the party, and the offensive covenant would remain in place because the court would not be satisfied the threshold was met. We say the court, if that test were to be introduced, it must at the very least look at the efficacy of the particular threshold or the particular alternative remedy. If we are to apply the property order, as my learned friend relied upon in this case, it's perhaps instructive to briefly look at what the property order itself actually seeks to achieve. You'll find that set out in Volume 1. It's tab 5, page 18. Section 4 of, Article 4 of the Property Order, Northern Ireland, 1978, gives the Lands Tribunal the jurisdiction to make an order declaring A, whether or not the land is or would be an event affected by an impediment, B, the nature extent of the impediment on the land, and whether the impediment is or would in any given event be enforceable. Of course, it is focused on the land. And as we saw the observations of Lord Harman in Petrofina, in restraint of trade, it is not the land that is restrained, it is the person on the land.
Sorry, I don't understand that. Are you saying that this doesn't apply?
It applies. Yes, it can be invoked and has been invoked in this case as a mechanism by which Peninsula is seeking to disrupt, as it were, the damage which may be done by this covenant. But what, of course, we say is this, that the fact that the covenant itself is offensive to public policy and therefore unenforceable. Why should Peninsula have to go to the Lands Tribunal for the Lands Tribunal to decide whether or not to amend something which is in restraint of trade and offensive?
So I was wondering why you were concentrating on the word land.
Well, simply because in terms of an effective remedy, it's not looking to the same issue as restraint of trade. If one is looking to a remedy which is effective,
But it's looking at 5.5 is giving it power to deal with very thing you don't like, which is the length of time.
well, if we look at the power, my Lord has set out at section or Article 5 over the page, and the issues the Lands Tribunal will take into account are set at Article 5, 5A, B and C.
I mean, are you saying that your prospective application under the order is doomed to fail?
No, my Lord, absolutely not. But our application under the order is an alternative means by which we can seek a remedy. But it does not mean that that option to seek an alternative remedy removes the protection of restraint of trade.
I mean, why are you saying in 4.1a, you point out, is the land affected by an impediment? It clearly is.
Absolutely, I accept that. But
I thought that was the point you were making.
No, the
Oh,
point-
there are all these difficulties. It refers to land.
Yes, but the focus, the Lands Tribunal, restraint of trade looks to the impact of trade impacting upon the person on the land. The Lands Tribunal, in relation to the impediment, the issues it looks at is why the impediment was imposed, the change of character in the neighbourhood, and in relation to public interest, it looks at the area planning, the strategic area plan. It's focused very much on development and on the land. Restraint of trade is focused on whether or not the business or trade is one which is in breach of the doctrine. And the point, my lords and lady, I'm making is simply this. At the threshold stage, the availability of an alternative remedy is not something that in some way immunes Dunstore from the application of the doctrine of restraint of trade. It is something which, in the fullness of time, may be something that...
I mean, it seems to me the only relevance of it is that it may be relevant if we're being forced to sort of reshape the doctrine of restraint of trade on the basis that the SO test is not very satisfactory. Then we're entitled to look at the whole framework, and the fact that there's now a legislative system in place may be something that we can take into account, but it doesn't go any further than that, I don't think.
But it doesn't tell the Lands Tribunal how a covenant in restraint of trade becomes unenforceable. It doesn't assist the Lands Tribunal.
So we're assuming at this stage it's enforceable, and we're asking whether to modify it.
But of course, our proposition is, if a doctrine is in restraint of trade, the authorities will come to the moment to demonstrate it is unenforceable from the outset. If unenforceable with the outset, there's nothing to go to the Lands Tribunal
we
with.
know that. I mean, the point about this is that if it is enforceable, then there is another means of tackling the vice which you say it has, which is that it's far too long.
I understand that, my lord. There may be an alternative mechanism of addressing that vice, but that, we're looking at the threshold test, and if one is developing a general test, in our respectful submission, to say that one looks to see whether or not there is a threshold and whether or not there's an alternative remedy imports something completely new into the test. It's the first point. The second point is it's going to require evidence on what that alternative remedy is. Thirdly, is it effective? And fourthly, behind all of that, of course, is that is removing the common law protection of a doctrine which is grounded in public policy. So what one would be saying, in essence, is a covenant or lease or whatever it may be, which is offensive to public policy, it's okay. You may have the remedy of going to Lands Tribunal, which of course won't, as a doctrine would do, remove it completely, but it may change it and make it less onerous. And it's therefore, to that extent, a much less effective remedy for Peninsula. Because if we're right, this is a restraint of trade, we, as it were, look to the result of striking down this particular covenant entirely, as was done in Harper.
But there's also another point, isn't there? And that is a matter of policy. It's dragging the courts into the question of to what extent should it be enforceable, rather than simply considering, does this meet the threshold test and is it justified? Yes. Which is a much more precise question, much more suitable for judicial interpretation.
We would submit and agree, my lady, that it, in bringing that in as a facet of the threshold test, introduces very considerable complexity. The final point I make simply on this point is that the property order enacted in 1978 came 11 years after ESO. If Parliament had wished to provide for the exclusion of the doctrine, Parliament would have been able to legislate for it. And therefore, in our respectful submission, it didn't, because there was no intention that the amendments in the property order should interfere with the common law rights of restraint of trade. My Lords, given the time, can I move on then to the question of successors in title? The significance at that point, of course, as I've already alluded to, depends on which threshold test is applied. But insofar as the argument developed by the appellant is concerned, it does not address the issue of third parties which can take action if affected by the doctrine. And the decision we cite in support of that proposition, there's a number within our written case, but given time, I will take my Lords to the lady to the decision at tab 17 of volume 1, the case of Newport Association Football Club versus the Football Association of Wales, 1994 judgment of Mr. Justice Jacob. Hopefully can deal with the facts quickly. MS 344, 3 Welsh football clubs, all of them were playing at that time in England. Why was that? Well, it arose because of a rule introduced by the Football Association of Wales, referred to in the judgment as the FAW. In light of that rule, that no Welsh club would be granted sanction, and there's a complex explanation of the relationship between the various football bodies and the circumstances in which a Welsh league could become subject to UEFA. I don't think we need to get too engaged with that. At page 346, top of the page, as a result of that rule, the 3 plaintiffs decided that they were going to join the English League and they were going to leave the FAW completely. Of course, their home grounds were in Wales, and the FAW retaliated and reacted by changing its rules and imposing sanctions, the effect of which they couldn't play their home games in Wales. So 3 Welsh football clubs with stadiums and grounds in Wales had to, in fact, play their home games in England. And the problem, of course, there was that the FAW and the clubs were not in contract. So Mr. Justice Jacobs deals with the question at 347. First of all, could there be a cause of action? Because the clubs were seeking injunctive relief in a declaration in relation to the particular arrangement in question. He says at 347 at E, Mr. Justice Jacobs finds well settled the contract or other arrangement is an unreasonable restraint of trade is merely void and unenforceable. In passing, my Lords will have seen in our written case, we have provided a whole series of cases where the use of the word void is found. In this one, we find both void and unenforceable. But I'm not sure much turns on the nomenclature one applies. Unenforceable means it cannot be brought before the court and used to enforce otherwise valid contractual rights. He sets out then the decision of Boddington and concludes, it does not follow there is no cause of action available to a party affected by such arrangement. It is well settled that such a party can bring proceedings for declaration that the arrangement is null and void. And he cites in support of that another football case, Mr. Eastham versus Newcastle United Football Club. And he then, moving to page 348, develops that point further at B. This is the key part of this judgment, which we would commend the court. It is true that the plaintiffs are not in a contractual relationship with the FAW, but it is well settled that a person who is not a party to an arrangement said to be void or unenforceable may apply for a declaration if he is sufficiently affected by it. There is a test. If you're sufficiently affected by it, you are given the right, if you so wish, to seek appropriate declaratory relief. And that, my lords and lady, in the statement of claim is what Peninsula are seeking, a declaration that they are not subject, or it is not subject to this particular covenant. And authority for that is the Mr. Easton's case against Newcastle United Football Club. He also cites Nagel and Felden, which is a decision we have referred to in our written case involving a female horse trainer who was denied by the Jockey Club admission on the grounds of sex. She was able to seek appropriate relief, notwithstanding the absence of a contractual relationship. There is perhaps more authoritative authority in the decision of the House of Lords in Dixon versus Pharmaceutical. Can I take my Lords to volume 3 at tab 45, page 971.
Sorry, give me the page again.
971, my Lord. And in this case, the Pharmaceutical Society had sought to introduce a new rule. The effect of that rule is set out at page 974 between A and B in the judgment. So this is the recitation of the facts, but sufficient for these purposes. The consequence of the rule was that pharmacists were essentially restricted in what they would be able to do within their shops and what goods they would be able to provide or sell. And the relevant section of the judgment for the purpose of my present submission is at page 1008. And this is part of the speech of Lord Wilberforce. Can I take my Lords to C on that page? Lord Wilberforce says, "It is of no materiality that members are not contractually bound to observe the rule." He refers then to McAllistrom. And then just above D, he says, "The doctrine of restraint of trade has never been limited to contractual arrangements," and then cites Lord Macnaughton's test. Just above E, he says, "Recently the House restated the generality of this principle by reference to the practical workings of the restraint, irrespective of its legal form." And then finally, just above F, to copper fasten the proposition that there is no need for contractual relationship, there was ample authority cited then by Lord Wilberforce. The Ipswich Taylor's case and a number of other cases are also referenced. Now, the point that gives rise to, my Lords and Lady, is if Peninsula, as the successor in title, is sufficiently affected, as it plainly is, by this covenant, then we say it does not matter that there is no contractual engagement or relationship at the time between it and Duns. It is subject to the provisions in the lease, it is subject to the covenant, it affects it undoubtedly, and there's ample authority to demonstrate if it is affected, it can invoke the doctrine. And that, of course, puts to an end any question of what it is or is not as a successor in title. Now,
so that's the way you, having said in answer to Lord Kitchin that we had better let sleeping dogs lie and keep to the pre-existing freedom test, and you knowing perfectly well that Peninsula had no pre-existing freedom here, that's the way you get out of it.
It, of course, my Lord, as I said at the outset, does depend ultimately on what test this court should determine is the appropriate test.
I know, but on the basis of that test, that's the way you escape its clutches.
Even if one applies...
Is that right?
Well, the pre-existing freedom test, if it is applied, the pre-existing freedom test, our answer to that, my Lords, is one goes to the point in time when that pre-existing freedom was given up. And in that respect, one has to move to a different basis on which Peninsula can rely to persuade the court as successor in title, if one applies Lord Reid's test, as successor in title, that it is entitled to invoke the doctrine.
I think you're saying to me, yes, that's the way I get out of this.
Yes, my Lord.
And that's not the way the Court of Appeal reasoned it.
No, it's not.
You wash your hands of that part of their analysis.
No, my Lord, I don't. And I'm going to take, my Lords, to a number of reasons why we say, as an alternative or other means by which, in fact, we get to the same result, that is that Peninsula is entitled to the benefit of the doctrine. First point, my Lords, is this. The authorities, we say, speak effectively with a completely unanimous voice that the time for assessment in relation to a covenant in restraint of trade is when it is formed. The authority most often cited for that is the case of Commercial Plastics versus Vincent. It's a Court of Appeal decision. I'm not going to take my lords to that because it's recited so often in the other cases. But first point, you go to the beginning to 1981 when the covenant was formed. Second point, once unenforceable, always unenforceable. Two authorities establish that principle. The first one is a decision of the Mogul steamship, Lord Halsbury, and it's in Volume 1. I can take my lords to the relevant statements very briefly. Volume 1, tab 16, page 320. Lord Halsbury, centre of the page, then you'll see the words almost in exactly the centre, the words restraint of trade, and then goes on to say, and contracts so tainted the law will not lend its aid to enforce.
I'm sorry, where are you reading?
Page 320, just
Yes.
in the very centre of the page, you will see the words restraint of trade. I think it is the middle line on that page, my lord. Contracts so tainted the law will not lend its aid to enforce. It treats them as if they had never been made at all. And then Lord Diplock's pronouncement on this issue we can find in the same volume, turning to tab 11, the decision of the Court of Appeal in Gledhoe Auto Parts versus Delaney. Lord Diplock's speech is found at page MS 191. This was a covenant in relation to an employee-type scenario. But at page 191, just above the E, bottom of paragraph marked D, covenant of this kind, one which is considered in restraint of trade, is invalid ab initio or valid ab initio. There cannot come a moment at which it passes from the class of invalid into that of valid. So it's measured at the time the covenant is entered into. It is either valid then or invalid, and if it's invalid, it is treated as if it had never been made at all. The appellant sought, faintly perhaps in submission, to rely on the first instance decision of Passmore to develop some sort of fluctuating position in handing over a bundle of rights. Passmore, we say, does not provide any authority for that in restraint of trade. It is a case solely concerned with the question of competition, where a very different test applies. But usefully, we do have that consideration of fluctuating rights addressed in the doctrine of restraint of trade in the case of Shell versus Lowestock. And that's to be found, my lords and lady, in volume 2, tab 21. Decision of the Court of Appeal, Lord Denning, Lord Ormerod, and Lord Bridge. Facts, my lords and lady, are set out at page 417. Let's take through those, hopefully succinctly. Lord Denning sets the facts out. First of all, it's a small garage, the Lowestock garage. It's been run by Mr. Clark. He also had set up a company, Lowestock Garages Limited. It had been tied to acquire Shell petrol for some 20 years in foot of a Solus agreement. What then happened, there was, in 1975, 20 years after, in fact, the Solus agreement had come into effect, there was a price war. Top of the next page, Lowestock was caught up in it and had to meet competition from, among others, two other Shell garages, one being owned by it and one being tied to it. As well as that, it had other non-tied garages selling petrol at a cheaper price. It couldn't afford to cut its prices set out at B, and Shell wasn't prepared to allow them to pay less. Lowestock took the view, Well, the tie has now been there for 20 years. It has expired. They told Shell, that's it. The Solus agreement is over. Paragraph 8, we can see the Shell manager, paragraph H, the Shell manager was of the view he thought there was 12 months notice required. He went off to look at that. Meanwhile, Lostock had had enough, and at the top of page 419, it moved on and commenced acquiring petrol from another supplier. Proceedings then were issued by Shell to require Lostock to comply with its obligations under the Solus agreement, it having failed to serve notice, terminating the agreement as required with 12 months notice. During then the course of proceedings at D, it turned out, in fact, that not only was Shell operating 2 garages close to Lostock, which were undercutting it, but Shell was even worse, supporting them and providing them a financial incentive. So Lostock was denied the chance to cut its price, it couldn't compete, and the party with whom it was in a Solus agreement was making that situation even worse. The judge at first instance, paragraph E, he held the effect of the support scheme was to inflict, as he described it, an unreasonable and unforeseen degree of hardship, and that Shell couldn't enforce it. The Solus agreement then is set out. There is then an explanation for why there was a change in the notice requirements. That was because of Shell. Page 428E, in 1966, there was a decision in the courts in which it was said that a Solus agreement might be an unreasonable restraint of trade if it exceeded 5 years, and it would seem that, as a principle, Shell ruled out to, and no doubt other garages did as well, or other oil suppliers did as well, varying the length of their covenants to one which was 12 months unwritten notice. And just for a point I'll make later make good, but I ask my lords and ladies to note at G that there had been a variety of transfers and assignments. Some point was raised by Lostock's counsel, Mr. Kemp, but the key point is that there was a transfer of the original agreement from Mr. Clark, who had been the private individual originally entering into it, to Lostock Limited, the company, which had entered into it then on that basis, already subject to the covenant. At page 422, we deal with the question of restraint of trade. And Lord Denning said, F, it is now settled beyond doubt that a Solus agreement is a contract in restraint of trade relying on ESO. Sets out the view of when reasonableness is assessed. We don't need to consider that, but the principal finding over the page 423 of Lord Denning, was to introduce this proposition or construct of a fluctuating validity. So he said, once it is recognised at E that the covenant itself is not invalid or void, but only unenforceable, the position becomes clear. It operates in 2 situations. First, when at the time of making the contract, it is seen that it may in the future operate unfairly or unreasonably, the courts will not enforce it. So if at the time you make it, it is viewed by the court as going to at some future time interfere with trade unfairly or improperly, it will not be enforced. Secondly, and this is the novel approach adopted by Lord Denning, if afterwards it is found to operate unreasonably or unfairly in circumstances not envisaged beforehand, the court will not enforce it as well. In other words, the doctrine is engaged. Now that view of Lord Denning was deprecated by the majority in the Court of Appeal. We can turn to Lord Ormrod, Lord Justice Ormrod, first of all, MS 426. He sets out the judgment of Kerjay, who at first instance had come to the same conclusion as Lord Denning. It could be a point at which the public interest meant that this particular covenant should not be enforced for as long as the particular imbalance persisted. And at page 427, Lord Justice Ormrod's views are set out. He sympathises with the view of the trial judge to relieve Lostock temporarily of their obligation to buy Shell petrol at an uneconomic price, but he felt there was no way to achieve that result in what he described as a completely novel way. There is no authority to support it. It would introduce into the law an unprecedented discretion in the court to suspend for a time a term in a contract. The repercussions of this are quite unforeseeable and unmanageable. For example, it would at once alter the approach of the courts to covenants in restraint of trade generally. It goes on then to explain why, in terms of the difficulties of dealing with suspension of contracts for a period of time. Lord
What
Justice,
are you getting out of all this? I mean, you're just saying that it doesn't apply. The majority say you can't have a fluctuating concept.
and that's Lord Justice Bridge makes the point good at page 428. He sets out at C his view that a contract cannot temporarily lose but then subsequently regain its binding character, and he cannot find any support. Having read Lord or the Master of the Rolls view, he was unprepared to go with it. So what do we say, my lords, that establishes, lady, this establishes in this case? If a contract or covenant in restraint of trade is determined to be such, it is unenforceable, then and for all time. And if it is unenforceable when it passes, there is nothing to pass that can be enforced against Peninsula, and Peninsula is entitled to seek a declaration to precisely that effect. What therefore, my lords and lady, we say on this point in summary, you assess it once and for all at the start. It's either valid or not. If invalid and contrary to public policy, it remains so. It cannot then be enforced against the original contracting party. It cannot then become enforceable against their successor in title. And therefore, and finally, my learned friends have presented no authority whatsoever for the proposition of this sort of fluctuating entitlement or enforceability in respect of restraint of trade. Two final points we make, which are fairly brief. Firstly, in fact, the doctrine has already been applied to successors in title. In ESSO itself, a careful reading of the judgment demonstrates that there was a disparity in the dates between the solus agreement being entered into and the mortgage and covenant, the covenant in the mortgage, which was the subject of the analysis. Just very briefly, my lords, if I ask you to look.
Well, we've read the LQR article of Dr. Hayden, and in his criticism of the pre-existing freedom test, he says Lord Reader seems to have failed to realise that in fact there was this change at the relevant time, which meant that on the pre-existing freedom test, there wouldn't be a restraint of trade.
I'm not sure, my lords and lady, that can necessarily be correct, because Lord Morris expressly deals with this point in the judgment at page 149, volume 1, tab 10. So unless Lord Reid was unaware, which one can't imagine would have been the
Well,
case.
anyway, we understand the points.
So simply this, what it means, my lord, is this. One, in approaching the doctrine of restraint of trade, the court has a discretion. In a number of cases, it has exercised a degree of discretion in looking at the reality of the situation. So just because if one applies the pre-existing freedom test in ESSO, the actual point in time in which the covenant was entered into was after the solus agreement, or AMOCA is the Australian case where the same issue arises, or Lostock, the case we just looked at, where in fact there was a transfer of the interest from the individual to the company. That issue does not seem to have arisen. And perhaps adopting the words of Lord Wilberforce in ESSO, it is a policy doctrine to be applied to factual situations with a broad and flexible rule of reason. And if one adopts the appellant's proposition, you adopt a completely rigid application of Lord Reid's test, failing to recognise that in 1981, Mr. Shorthall personally entered into a covenant, 2 years later assigned his interest to a company of which he was a 99% shareholder and his wife held the other share. And if, my lords, this is a doctrine, as we say it is, based on public policy, that transfer and the significance of that transfer, at least in this case, would elevate substance, elevate form over substance. If the court were to conclude, and for the purpose of this submission, let the court assume that this covenant is offensive to public policy, is in restraint of trade, what that means is because of this particular transaction, of the nature as described, Mr. Shorthall is denied protection because of a rigid application of a rule which has not, it seems from the authorities, always been applied rigidly. And if there is a discretion, or if there is a room or a margin for looking at the real facts and the circumstances behind the case, as Lord Morris did in Esso, well then, my lords, we say that in those circumstances, this court can do the same. So, my lords, I'm moving on finally then, briefly, I can say, to the alternative test. Our primary submission is, as I said earlier, letting sleeping dogs lie, as it were, stick with Lord Reid. It has been around for some 50 years. It provides a clear dividing line of those cases which are subject to the doctrine and those which are outside it. One of the main criticisms certainly Hayden introduced was this distinction between lessors and lessees. As I hope I outlined to the court yesterday, there is a distinction, in fact, in relation to those, because one is on the land and stuck with it, the other can come to it. In relation to the trading society test, it's complex evidentially. It gives rise to analysis of public policy at the first stage of threshold, and we say that that gives rise to a complex and difficult test for application in practice, particularly at first instance. On either test, of course, we say that Peninsula meets it. If neither of those tests commend themselves to the court, well then, interestingly, my lords, Nordenfelt in 1895 and the decision of Lord Macnaghten provided a definition of restraint of trade and how it should apply. So in reality, from 1895 until 1967, there was no clear threshold. It does not appear that in that period of over 70 years, the courts were troubled with people knocking down the door with complaints about restraint of trade. And therefore, the absence of a threshold test, historically at least, did not give rise to the concerns which my learned friend seeks to outline of floodgates opening. In relation to that proposition, of course, if one were to take the simplified test of Lord Macnaghten, is it a restraint of trade? Albeit I accept my lady's observations as to it can't just be as simple as that, but nonetheless, if one applies a much more simplistic test of restraint of trade, well, every employment contract up and down the land, they're not subject to the threshold test in the sense of Lord Reid's test, and every employment lawyer, employer, in drafting those, has to have regard to the need to keep them reasonable. Why should land or other contracts be any different? A simple test, we say, is in the public interest. If covenants of whatever form are unreasonable, this doctrine is grounded in the public interest, and therefore they are contrary to the public interest. Why should those covenants or contracts be free from being challenged or immunized from challenge by an arbitrary threshold test? In relation to land, it is perhaps unlikely that the vast majority of common or standard covenants would engage the doctrine because they would be in any event reasonable, and the law would develop to meet the cases, no doubt, on a case-by-case basis. The issue for the court is, if one moves from Lord Reid's test, it is not necessarily an easy task to define what should be the appropriate threshold test, and we suggest or submit that simplicity perhaps is key, or one of the benefits of the test that we have proposed. It's very much a matter for the court, and we accept to analyse which may be best. So, my lords, finally, my conclusion, what we say is...
So what is your alternative test? I'm looking at your case.
The alternative test, my lord, we say is a simple test of, is it a restraint of trade? Essentially, Lord Macnaghten in Nordenfelt asked, is this particular covenant a restraint of trade? And if so, can it be justified? And that is justified, first of all, in the interest of the parties, and second of all, in the public interest. And if one applied that test to this case, we say, of course, this is a restraint of trade. It restrains, as we submitted yesterday, this particular developer in relation to the use of his land. And on that point, just briefly, in conclusion, It would be odd indeed, we submit, if development or developers who engage in the sale or supply or dealing with property on land should be excluded from the doctrine. Why should they, in their trade or business, be different from any others? One of the points which is made as well, there hasn't been a great deal of authority in this area, and that was particularly the case in Esso. Well, that's why we opened the historical background to the court. There's not a lot of authority because of the historical background in terms of partial and absolute restraints. But when this matter came before the House of Lords, even in those circumstances, in the absence of all the clear authority and leasehold type covenants, Lord Reid, Lord Morris, and Lord Hodson, each of them separately considered that the giving up of freedom in respect of land was something that was worthy of protection. Indeed, not only that, my lords, Lord Pearce himself, while he didn't support it perhaps, he certainly recognised that it may come within the possibility. Petrofina, Lord Denning, independently came to the same view, that there is a need, it is proper that the law should provide a protection to a lessor giving up some right or interest or freedom in their own land. And, my lords, what we say is this. On a densely packed island nation such as ours, with finite land, with all sorts of pressure in relation to the use of that land, where a doctrine is grounded in public interest, we say it's clearly right that the courts should wish to review contracts which tie up individuals in relation to what they can or cannot do in relation to their own land. That is why there is a distinction to be drawn very clearly between the lessor and the lessee. And it surely, my lords, we say, to adopt from Egon Zender at paragraph 23, Lord Wilson's words, it must be in the public interest in a nation subscribing central importance to the freedom of all to work, that developers, like any other, should not be subject to restraints in relation to who they can deal with in relation to their own land. And we have seen the Canadian courts certainly were prepared to accept that proposition. And so, my lords, in final submission, we say a 999-year lease tying up these lands in relation to what use can or cannot be made of them by the person in occupation of them, subject to that covenant, at the very least calls for examination as to whether or not it is justified in the interest of the parties or in the public interest. And we submit that the threshold test is met. My lords, unless there's anything else I can address, I think that is within my time slot.
Apparently there's nothing else. Thank you very much indeed, Mr. Dunlop. Mr. Fletcher, do you follow? Well, we hope that on the next occasion you come to the Supreme Court, you'll have a speaking role, Mr. Fletcher. Yes, Mr. Humphreys.
My lords, my lady. In terms of what we wish to say in reply, I hope to keep this relatively brief, but there are some key issues raised in my learned friend submissions that I do need to deal with. The first is really to pick up that latter point about Mr. Shorthall's position as developer being able to invoke the doctrine of restraint of trade. And we say that for all the ink that has been spilt in the case and the many authorities we've all had the benefit of looking at, that is a very fundamental and simple issue for the court to examine before it needs to go anywhere else. Is this properly understood as a restraint of trade? Or is this a restrictive covenant entered into by a developer for mutual benefits, both between him and his tenant and in relation to the future development of land? And we say clearly it's the latter. If there is a restraint of trade here, it's upon the business of future tenants. It's not upon Mr. Shorthall. Mr. Shorthall remains at liberty to deal with whomever he pleases in relation to the land, provided he remains within that limitation in terms of size and nature of business.
But the tenants with whom he contracts would be similarly obliged, wouldn't they? He would be bound to get covenants.
He would be.
So that they couldn't sublet. So everyone's affected by this.
Yes, but that also illustrates the structure of the matter. It would be strange indeed if the retailer who enters into the lease with Mr. Shorthall in 1982 following the 1981 lease to Duns, enters into a covenant saying, I won't sell groceries, textiles, or provisions in my store, if he could then come along and say, but that's an unlawful restraint of trade, Mr. Shortall would presumably say, well, you can't say that because you've come to the lease. You haven't given up a pre-existing freedom. But yet I, who's not directly impacted by the restriction, could make the same complaint to Duns. That just strikes one as being, certainly a lay person would regard that as being just bizarre. That the retailer couldn't make the complaint, but the developer who's in the business of letting these properties could later on say to his anchor tenant, I object to that covenant which I entered into. That's just, I think, an irrational view of how property development should
Sorry, I
take
don't
place.
quite follow that submission. Could you just elaborate it for me?
So if one imagines you're one of the 14 retail units that Mr. Shortall subsequently secured
Yes.
at the property, if one of them was, say, selling sports goods and decided it would really like to retail clothing alongside the sporting equipment, and Mr. Shortall was to say, well, I'm afraid you can't because you would breach the covenant in your lease that says you can't trade in those goods. And if the retailer were to say, well, that's a restraint of my trade, Mr. Shortall could respond, well, unfortunately, the law says that you've come to the lease, you haven't given up a pre-existing freedom, and therefore you can't invoke the doctrine. But yet he, Mr. Shortall, could sit back and go, actually, I'm going to invoke the doctrine as against Duns Stores, because I have given up some freedom or some trade that allows me to invoke.
It may depend on which test you apply.
Well, it does, of course, but on the logic of the law as it currently stands, that would be the situation, which my learned friend is still upholding the pre-existing freedom test as the appropriate one. But that was the outworkings of what he's saying, is that Mr. Shortall would be able to invoke it, but yet those retailers who haven't given anything up wouldn't be able to do so as against their own landlord. And that would be a surprising outworkings of a doctrine which has at its core the issue of public policy. And that's why we say Mr. Shortall is entirely different from the baker or the songwriter or the dyer, the brewer, all those people who are properly understood to be in trade in the provision and selling of goods and services. He is in a very different position as a property developer interested in the orderly development of his lands.
Well, let me put another case to you. Supposing it's a term of a contract between a developer and a senior employee that the employee won't set up a competing property development business within 400 miles. No doubt you would accept.
Yes, then
Would you not accept that the doctrine would apply in those circumstances?
Yes, we're there into a paradigm case of employer-employee, the familiar territory, as it were, the inner reaches of the doctrine we all accept, and employment lawyers all accept, the doctrine will apply. And
So the subject matter doesn't exclude it?
no, the subject matter doesn't exclude it, but the nature of the transaction does. So it's not as if property developers could never have issues around restraint of trade. It's that they don't do when it comes to the arrangements by which they lease and sell and transfer their lands.
Supposing a property developer decides to split its business and dispose of half of it, and undertakes in relation to the purchaser of the half of the business that it won't compete in a certain area.
Yes, again.
Does the doctrine apply to that?
Yes, it does. Paradigm case, vendor and purchaser of business. And again, those involved in the creation of commercial contracts for share purchase and asset arrangements very well know that those types of restriction will be examined for their reasonableness. And so from a legal certainty point of view, those two categories are neat and understood. What we're dealing with here is the more nebulous category of where the doctrine reaches. And this is the difficulty for those involved in conveyancing, if in fact it's determined that the doors of restraint of trade are going to be open to all restrictive covenants, none of those covenants in typical leases have been drafted with the notion of reasonableness in mind.
In both of the cases I've put to you, there would be a restraint of trade.
Yes.
So you accept that the business of property development is a trade.
Well, the question around the employee going elsewhere, the employee of a property developer could easily say that my business, my trade. The split of a business, in no matter what the subject matter of the business is the sale of a business is always regarded as being subject to this doctrine if there are restrictions on competition subsequently. But in this situation, where we're dealing with the transfer or leasing or selling of lands, that is not quintessentially a trade.
Well, Mr. Shortall is in this case also undertaking a restriction as to the way he can deal with his land.
He is.
So why isn't it in the same way a restraint of trade?
Because
You may say it isn't. It's not a transaction to which the doctrine applies because of the nature of the particular contract, but it is it not, a restraint on his trade?
No, it's not, because all it does is provide a framework within which he can negotiate deals with future tenants of land.
Does it not restrict his ability to negotiate future deals?
No, well, for a start, it doesn't impact, of course, any other land he has. It only impacts the lands that are subject to this particular restriction. And it doesn't prevent him doing anything other than the limitation on size and on the nature of the goods that can be sold.
A small limitation.
Well, there is a restriction on what business he can transact following the lease. I accept that. But that is not, we respectfully say, a restraint of trade properly understood.
Within the doctrine?
Within the doctrine.
Yeah, I understand.
But the real vice is people taking restrictions on competition.
Yes.
And that's what we're looking for.
That's
So why
right.
shouldn't that apply whether it's a trade or business?
What we're concerned with here is the competition element has to be lawful. So at any stage, we have our competition legislation, which is available to anyone who complains about anti-competitive agreements. But more generally, the restraint of trade doctrine is concerned with protecting individuals from unlawful interferences with their trading and business rights.
Goes beyond that because we have to look at the public benefit too.
Yes, that's correct. And the public policy element of this should really be front and centre to whatever the outcome is, as well as whatever test ultimately is postulated. Is there something offensive to public policy in a lessor entering into this type of arrangement and finding himself restrained by it?
Well, it may depend upon the extent of the restraint.
Well, it may, but
Supposing the restraint is highly unreasonable and was entered into by the lessor for his own particular commercial reasons at the time, but objectively it's highly unreasonable and it has a significant impact upon the public's ability to buy goods in the sphere with which the agreement is concerned.
that may come into Justice Gibbs' analysis in Quadremain. What he says, and that's a significantly higher level of authority than many of the cases we've looked at, a 7-person High Court of Australia in Quadremain, looked at the issue of restraint of trade and restrictive covenants. And what Justice Gibbs said was that, in general terms, the doctrine has no application to someone coming to a lease and entering into a covenant, no matter how onerous that covenant may be. It equally, he says, has no application to the purchaser of land with an existing restrictive covenant thereon. So the Peninsula Securities situation, we say. So the purchaser who comes along and sees a restrictive covenant on the title is bound by it. And there's no reason in public policy to say that the law should intervene in that situation. As a matter of generality, he does say that there may be cases on the extreme edges where it's felt that there has to be some intervention, where perhaps the covenant goes so far beyond what's normally understood in the trading society that there is a need to intervene. But those need to be, and fundamentally that's our submission, that the intervention of the law in this area should be very carefully limited. And that seems to follow the quadrimain analysis quite closely. In this particular, it's interesting to pick up on some of the evidential points my learned friend relied upon when he was discussing whether, if the trading society test or some version of that were adopted by this court, how that might impact on the instant decision. And without being unfair to my learned friend, he did rather cherry pick the evidence on this issue, because one can see from the first instance judgment of Madam Justice McBride, and indeed from the affidavit evidence of Mr. Shorthall that's in the papers, there clearly was a negotiation around these contracts. And moreover, from the uncontested evidence of Mr. Farris, who was the commercial conveyancing solicitor representing Dunn's Stores back in 1979-1980, he said that he'd suggested a term of 125 to 150 years, but it was the solicitor for Mr. Shorthall who asked for a 999-year lease. And that's at paragraph 36 of the judgment at first instance.
That must go to reasonableness.
It certainly would on the pre-existing freedom analysis if we're having the Lord Reid threshold test followed by the reasonableness inquiry. But if we're in a trading society analysis, those questions about the negotiation that preceded the agreement, the representation of the parties, etc., come into the threshold question, it seems. There is then that melding of the two issues, but it's certainly relevant in a trading society that people have representation and negotiate their deals and aren't simply having standard terms foisted upon them, and that the trading society would regard rather differently a situation where there's a take it or leave it deal on the table in perhaps circumstances of economic duress or necessity, rather than a freely negotiated agreement where indeed the purportedly onerous part of the lease was actually proposed by the lessor himself.
But how does this all matter? Because the second half of the test on justification does involve, doesn't it, looking at the public benefit?
But it does matter if we're looking at trading society.
Yes, but if they get over the first threshold question and get into justification, then of course you can go into these issues. But at the end of the day, the court also has to ask, was this in the public interest?
It does if you get to the second question, right. Indeed.
So,
but if you say, well, in a trading society, we should respect freely negotiated land transactions with representation between parties who are of roughly equaling bargaining power to carry out commercial business, then the inquiry stops. We don't reach the issue of public interest because the threshold, we say, hasn't been met. There's also, the court has the point that the evidence was given that these types of restriction were not uncommon, albeit that the expert couldn't specifically comment on the issue of the covenant vis-a-vis this length of lease. But in terms of the factual finding, at first instance, it's important to pick up at MS 1638 what the learned trial judge was saying about having heard the evidence. MS 1638 at paragraph 77. She says, fourthly, I find there are public policy reasons why the doctrine does not apply to original lessee covenantors and purchasers, and why it also does not apply to successors in title of covenantors. The covenant in this case is typical of restrictive covenants which apply to both leasehold and freehold lands. These covenants have been in existence and enforced for hundreds of years, even though they restrict trade. If the court were to overrule such long-established principles, I find it would cause much uncertainty and would adversely impact commercial dealings with land where certainty is required. So she does find that these are typical restrictive covenants, and importantly, not just in leasehold lands, but also in freehold lands, because Mullern and Friends' complaint about the length of the obligation here stands in contrast to the fact that there is no difficulty, we say, in having the same restriction imposed in perpetuity on freehold lands. Now, that could only be enforced under Tulkin Moxey by the owner of adjacent or proximate lands. It couldn't be enforced simply in gross. But in this type of situation where you do have owners of proximate land, if we were simply in a freehold scenario, if Mr. Shorthall had sold a freehold interest to Duns but imposed a restrictive covenant therein, that would remain enforceable. The benefit and burden would remain between those owners of adjacent and proximate land and their successors in title under Tulkin Moxey. So it makes the complaint about duration rather difficult to make good, we say, whenever there's no legal offence committed by having it as an obligation in perpetuity.
May I ask this? Are we in a position to make an assessment for ourselves about the matters to which the judge referred in paragraph 77 of her judgment?
I think
Was she entitled to?
I think she heard the evidence from. She had evidence from a conveyancing solicitor, from a property expert, and the parties themselves. So she was perfectly entitled, respectfully, to reach that finding. This court will, of course, accord that the respect of the fact finder having heard the evidence. But this court's also in the position now, having looked at the array of authorities and so on, to consider a bigger picture, as it were, across the Commonwealth and so on, as to how frequent this type of arrangement in shopping centres is. And certainly those Australian cases and the Canadian cases make it clear that these are relatively common obligations involving anchor tenants at shopping malls globally. And of course, Mr. Hayden's book also has many references to American case law and so on. So they are a worldwide phenomenon, and one might expect that in a consumer society.
There was specifically evidence of the matters to which the judge refers at 76.
Yes, and that's the basis on which she made those findings. The principal objection throughout Mullern and Friends' submissions did seem to be to the length of the covenant. And that, aside from the freehold covenant issue, which is really a sort of theoretical submission, the reality here is that that's not the complaint that Peninsula Securities brought to the Lands Tribunal. If one looks at Appendix 2, MS 1977, that's internal page 376, electronic bundle 1977.
What was the internal page number?
376.
Thank you. Yes.
This is the notice of reference to the Lands Tribunal under the Property Northern Ireland Order in 1978. And the court will recall this back in 2010. And this is a standard form document which is prescribed by Lands Tribunal rules. And one can see that the first paragraph sets out the person making the application, Peninsula Securities Ltd, the statutory provision, Articles 4 and 5 of the Property Order, which is the power to extinguish and modify restrictive covenants. The land is described as Springtown Shopping Centre. The interest of the applicant is set out as, in paragraph 4 as being the owner of the shopping centre. The predecessor in title granted a lease to Dunnes Stores Bangor Ltd, which contained a restrictive covenant that any development on Peninsula's lands, quote, shall not contain a unit in size measuring 3,000 square feet or more for the purpose of trading in textiles, provisions or groceries in one or more units. And the determinations sought by the applicant are, one, that it was an unreasonable restraint of trade, and we know that the tribunal didn't have jurisdiction to deal with that issue, and that litigation followed. Roman 2, an order the covenant be extinguished on the grounds that the impediment unreasonably impedes the enjoyment of the lands by the appellant, which is one of the possible heads of relief available under the 1978 order, a complete extinguishment of the covenant. But Roman 3, importantly, an order that the covenant be modified so that any development on the applicant's lands would not contain a unit in size of between 45,000 to 55,000 square feet or more, rather than 3,000 square feet or more. And then there's other information contained within the notice of reference that's required by the rules. So one reads the notice of reference, one doesn't even see a mention of the duration of the lease. Even the description of the applicant's interest as a matter of narrative, it's not mentioned that the lease was 999 years long, nor is there a complaint specifically that that is why the covenant in question constitutes an unreasonable impediment. Rather, it's about the size of the units. What Peninsula wants is to increase the scope of the size of the units which are permissible at the shopping centre. And so it's rather unusual that 10 years later, the focus of the complaint is all about duration, and not, as it was then, about the practical outworkings of the covenant in terms of the size of the tenant's premises that would be permitted at the site. We had the opportunity overnight to look at the Canadian authorities. I don't think I need to say very much about them. The first one, BACM, really just operates from Nordenfelt. And Nordenfelt is really my learned friend's alternative test, which is everything's in restraint of trade unless it's reasonable. And for some reason, Council in that case perhaps hadn't picked up that ESO had been decided by the House of Lords, even though it was some 4 or 5 years earlier, because it's not referred to even in passing.
So, I mean, you would say BACM is just wrong.
Yes.
English term.
Indeed, it's simply wrongly decided. And is, if not wrongly decided, then per incuriam in any event, because they simply didn't have the benefit of any analysis of the key issue of the threshold. In the McDonald's case, at least did have the relevant authorities mentioned to the court, but from paragraph 41 of that judgment, there is just an assumption that the covenant applies to the lessor. There's no consideration of why that's said to be so, and it certainly doesn't take into account the reasoning of the High Court of Australia in Quadramain, which was in 1976, so quite a long time before McDonald's, which is to the effect that the public policy shouldn't intervene unless there's a clear reason to do so. So I don't think I need to say a lot more about those. The point that was raised about Tulkin Moxey, my learned friend did say...
I beg your pardon, just before you go on, do you have anything to say about the convenience stores case or the specialist diagnostic?
Yes, I'll speak about specialist diagnostic in a moment.
Very well.
Just, I wanted to,
yeah.
so the order I have them here is Tulkin Moxey. It's said that it's not mentioned in ESO Petroleum. There's a very good reason for that, and it goes back to my fundamental point about the difference between personal restraints and issues around land. There is no neighbouring or adjacent landowner in ESO and Harper's Garage. So Tulkin Moxey could never have any effect there. Tulkin Moxey only prescribes what happens between adjacent or proximate landowners. It doesn't have anything to do with the running of personal covenants or covenants in gross. So I do want to pick up then on the specialist diagnostic case in the context of what I said about Quadramain. The judgment is at MS 658. And I think the most helpful parts of the specialist diagnostic judgment are at pages 673 to 679. The judgment itself is at tab 33 of volume 2 of the authorities. My learned friend Helphy took us through some of the reasoning that took the court to the point that it assumed the trading society test applies, which is paragraph 56 of the judgment. The court also talked about the protein quality of the public policy, and at paragraph 58, the initial formulation of the test accepts that a restraint will fall to be examined if in an individual case there is some greater than usual restraint of an individual's right to trade or an artificial use of an accepted technique. And so those are the boundaries of the trading society test. You have to show, or the court has to be satisfied, that there's some greater than usual restraint or some trick being played with a technique before the threshold will be passed and the question of reasonableness examined.
Do you adopt that then?
Yes, if the court's view is to move towards the incremental style of test, this is the territory we say we're in. That the normal course of business should be respected, that the normal conveyancing techniques and commercial agreements should be upheld without an examination of reasonableness. But if there is some greater than usual restraint or something unusual about the transaction itself, then that will lead the court to the second stage. And as I think I said in my submissions yesterday, it may ultimately that unusual technique becomes normal and therefore the inquiry would cease. But in the initial period at least, the intervention to that second question may be required. And
it wouldn't be triggered in this case by the length of the covenant?
It wouldn't be for the reasons I've said. Firstly, that it's not actually the complaint that this particular party has. And secondly, in any event, freehold covenants are readily upheld and they have no time limit whatsoever. It has to be the substance, we say, rather than simply the time.
But surely it's part of the restraint when you're asking, is it a greater than usual restraint? You look at the totality of the evidence about it.
Well, that's where one looks at the evidence that we have in this case and the finding of the judge to say, well, it's not unusual. These types of covenant are regularly features of freehold and leasehold lands. And if they're features of freehold land, then they're in perpetuity.
Yes. I wasn't aware that the judge had dealt with the question of time exactly.
Well, that's the only way she's dealt with it, is to say that they are a feature of freehold property transactions as well as leasehold ones. And ergo, that means the obligation is binding in perpetuity. The paragraph 59 takes that point to the next stage to say that there's a well-established line of authority for the proposition that the rules relating to restraints of trade do not ordinarily apply to restraints accepted by a party acquiring an interest in land. So do not ordinarily apply doesn't mean there's a blanket ban on the doctrine in relation to land transactions, as Robert McGarry would have invited the House of Lords and ESO to accept. And in paragraph 61 and 62, the court goes on to say that simply because it relates to land doesn't mean it's not subject to the rules. So when is it? Paragraph 64 is probably the answer when it says, it may be accepted that ordinarily the alienor of part of the land may be able to bind himself or herself with respect to the use of the balance of the land retained after a partial alienation. As Symbian submits, such provisions are common in leases of individual retail premises within shopping centres or other standalone facilities. So no blanket restriction, but there you have in that paragraph the court's view on the ordinary course of business land transactions in business of this nature. There are 4 reasons then postulated by the court later on as to why the restraint of trade doctrine should apply in these particular circumstances, having accepted the ordinary position. And it's useful to look at those, to compare them to the more run-of-the-mill cases. And you'll see those at 74 through to 78, my lords, my lady. The four reasons are that at 75, the obligation constituted by clause 20.1a extends beyond the land retained by the lessor, and it would be anomalous if the geographic extent of the obligation couldn't be examined by the court. Now, it might be said, is that not similar to the instant case? Well, it's not really, because all we're dealing with here, as you saw on the map yesterday, is one small strip of adjacent land. It's not that the lessor has bound himself into some wider 3-mile or 10-mile radius type case. It's simply effectively the lands at the shopping centre, albeit that one strip is held under a different title. The second reason that the court thinks it may be appropriate to intervene is that questions of public interest might arise in respect of restraints upon the supply of essential medical services. So that's very much a subject matter based issue. These are hospitals providing, obviously, services which are quintessentially in the public interest, and it may be that that's a particular feature that needs to be examined in that case. We say, obviously, it's very different from the retail provision in the northwest of Northern Ireland. Thirdly, the court says there is no evidence of an accepted practice relating to restraint of trade limitations in respect of covenants given by hospitals granting exclusivity to pathology providers. Again, very fact-specific and based on the lack of evidence at first instance about accepted practice. Again, a very different consideration, we say, than applies in our case. And finally, the clause itself raises questions whether, in any event, this particular provision goes beyond the sort of restraints of a right to trade commonly embodied in exclusivity provisions in commercial leases, and would fall to be examined under the proviso to the trading society test. So the judge is there saying that this is an unusual scenario. It's not something that the courts perhaps have come across before, or indeed have heard evidence that has become an accepted part of trade or business. And again, that contrasts directly with the position in the Peninsula and Duns land arrangements. In terms of the test to be applied then, if the court is minded to depart from the pre-existing freedom test, you have my submissions on how the trading society test might work. I note from the learned friend's submissions this morning that he's retreated slightly from the alternative test back to the safe haven of pre-existing freedom, but he would rather like that to be a sort of amended version of pre-existing freedom, which would recognise that it applies to successors in title. Now, that's clearly not the law at the moment, and you have my submissions on that. But through use of the line of authority typified by the Newport football case and Nagel and Fielden and Dixon Pharmaceutical Society, my learned friend seeks to contend that it is open to third parties or non-parties to invoke the doctrine. And of course, there is that specific line of authority around regulation, where a particular member of a society or somebody who would like to join a society or is subject to its rules may not be able to establish that they're in a contractual relationship. And so the courts close that gap by permitting declarations to be made about restraint of trade. We say that that line of authority, whilst interesting, and there's interesting academic debate about economic torts and so on, simply doesn't apply in this situation, because Peninsula Securities and Duns Stores are actually in a binding legal relationship. They're not in the same position as the frustrated horse trainer in Nagel or the disappointed pharmacist in Dixon. These two legal entities are bound together by the lease of which Peninsula took the assignment. Their rights and obligations are defined by it, and they each have the right to enforce obligations against one another through it. And therefore, there's no need for the court to import the reasoning that went behind those cases in order to create proper remedies or relief for either party. And in fact, to do so would simply, we say, drive a coach and horses through the pre-existing freedom test which my learned friend seeks to uphold. So his version of the test to be followed by the court is that it doesn't apply to anyone who hasn't given up a pre-existing right unless they're affected by the restraint of trade. And that really renders the first part of that test redundant, because it's got nothing to do anymore with pre-existing freedoms or rights. It's simply about whether you're affected. And you can walk up and say, I'm not happy with this arrangement, I'm going to invoke the doctrine. And that would be like saying that the prospective tenant of one of the 14 units at the shopping centre could say, I'm not happy with this. If you are Tesco or Sainsbury's and you'd like to open your supermarket in Derry, can you go along and say, I'm like Nagel and Fielden, or I'm like Dixon, the Pharmaceutical Society, I'm affected by this restraint of trade, and I'm going to issue proceedings for a declaration that it's unlawful, even if, conceivably, both Peninsula and Duns were perfectly happy with the arrangement, and neither of they sought to escape it or rely upon the doctrine. If that's right, that would be an extraordinary development in the law, and not a welcome one. One would think for either landlords or tenants that their arrangements could be challenged willy-nilly by third parties or officious bystanders who wish to interfere in their affairs. And of course, there is a remedy for non-parties under the Competition Act, but it's quite clearly prescribed, and in the public interest has to be something that impacts upon the market, not simply a private law that's one that would wish to pursue. My lords, my lady, I'm conscious also of one final point, which is that in our discussion yesterday around the meaning of the covenant, my lord, Lord Wilson, raised the issue about provisions and what that means. And I was reminded overnight of the work of the great jurist A.A. Milne, when Winnie the Pooh and Christopher Robin have an exchange about going on an expedition to the North Pole. And Christopher Robin says, we must all bring provisions. And to which Winnie the Pooh replies, bring what? Things to eat? Oh, said Pooh happily, I thought you said provisions. So on that basis, although Pooh might be confused around the meaning, I think the general acceptance is that provisions means things to eat.
Oh, does it? Yeah, right. Right. Well, it's time to have some provisions.
Indeed, that's right.
Have you finished?
I have indeed, my lord and lady, thank you.
Mr. Dunlop, you have no right of rejoinder. Nevertheless, do you want to say in one sentence any comment about your Lands Tribunal application, which complained of square feet, but not of length?
Yes, my lord, because the page 377, you will see that the third issue relates to the modification of the covenant, but numbers 1 and 2, 1, a declaration is in restraint of trade.
Well, we looked at that.
So that, it may not be worded, and there's no requirement to define in the form precisely what the basis of that argument is.
I see.
And therefore, my lord, it was not there.
Thank you. This has been a fascinating case to listen to. The quality of advocacy from Northern Ireland has been very high, and the court is grateful to the solicitors for a lovely preparation of the bundles, etc. Those with a non-speaking role, like Ms. Gray and Mr. Fletcher, and of course the two speaking advocates. We'll now retire to consider our judgments.